Welcome to Red, White, and Blue. I'm Gary Polland from the right.
And I'm Dallas Jones from the left.
This week on Red, White, and Blue, we're going to talk about a report card on bail bond reform in Harris County. And we have two guests that are knowledgeable, more than we know, about this topic. First, we have Vivian King, who's First Assistant and Chief of Staff for Harris County District Attorney Kim Ogg. And our other guest is Alex Bunin, the Harris County Public Defender. Welcome to both of you. So my first question, whoever wants to take it can have it. Who wants to explain to our audience what is a bail bond and what is its purpose in life?
All right, I'll try. Bail bond is simply a promise that someone will appear in court, and it's usually backed up by a promise of money. So in Texas, we have what are called personal bonds, which you don't put up any money first, but you promise that if you don't show up, you will owe money to the court. And then we have what are called surety bonds or bail bonds, in which you either pay all the money that is will guarantee you to appear, or you go to a surety bondsman that you pay a fee to, and they will put up the money.
Okay, and then I guess Vivian, we'll let you have at it. What is the genesis of bail reform in Harris County? Where did that come from?
Well, it started with the O'Donnell lawsuit that was filed in federal court. It's before federal Judge Rosenthal. So Miss O'Donnell was a lady charged with driving while her license was suspended, which is one of the lowest misdemeanors you can get, really a hybrid Class B misdemeanor where the maximum punishment is 180 days in jail and a $2,000 fine. Because she didn't have the $500, which at the time was the minimum bond amount, she could either put up $500 cash or hire a surety or a bail bondsman to put up the $500, in which she'd pay a fee, generally 10%, but with $500 bail bonds, a lot of times the sureties would charge like $150 to $250. If you don't have the money to do that, then you stay in jail. So that means Miss O'Donnell could not pick up her children from school. She could not go back to work until that money was paid, or she pled guilty to get out of jail. And that was a very coercive system. And I was definitely in favor of giving more PR bonds for nonviolent offenses.
For people like Miss O'Donnell.
For people like Miss O'Donnell.
So just to follow up on that, so Miss O'Donnell personally didn't file the lawsuit. There was a nonprofit organization that came in, Civil Rights Corps. They came in from D.C. They teamed up with a local private firm and found plaintiffs, and she was one of them. In fact, you have to find people that are actually in jail waiting to get out to have plaintiffs for this lawsuit. And they filed it, and it ended up in federal court, and they challenged the system which kept her in, which was the money bail system.
So the issue was never cut and dry, particularly not here in Harris County. It was an issue that was extremely contentious as we are going through the primary season. It has become one of the litmus for the criminal justice system here in Harris County, particularly in the Democratic primary. Understanding what you all have just kind of broken down in terms of what a bail bond is and the variety of ways you can do that, why and how did it become so contentious here in Harris County?
Well, originally it was contentious because there was a real political split. The Republican judges, county court judges who oversaw misdemeanors wanted to fight the lawsuit, and the county supported that. So there was a big fight, and it cost millions of dollars to fight it. And then finally, in the last election, they were replaced basically by all Democratic judges who wanted to end the lawsuit. So a settlement came after that. Now the step is how we're implementing that bail reform and how will it affect the felony courts. So that becomes a little more contentious because you hear anecdotes about people getting out, committing serious violent crimes. So it's going to be a little bit more contentious now that we get to felony bail.
Are we supposed to be, in both of y'all's theory, are we supposed to be balancing not having poor folks stuck in jail just because they're poor and they're not really a threat to society, with safety for the public from the real criminals who are in the system too? Because I can tell you, I've done some reviewing of what's happened, and I will tell you, I'm appalled at some of the people who have been released under this system, and it looks like the system's got lots of holes. I don't know, maybe I'm missing something.
Well, I agree with Alex. The lawsuit was named in the name of Miss O'Donnell, even though the nonprofit and the lawyers did it. But it was against the Republican judges. They were suing the judges because judges said bond. So be real clear about that. And all 15 county court judges were the ones being sued, we added a 16th court, which was Judge Darrell Jordan, who was the only Democrat. So that is the way it started. And as Alex said, when we changed to Democrats, then that it settled pretty easily. And basically, nobody that's similarly situated to Miss O'Donnell is sitting in the Harris County Jail. They all get PR bonds by the magistrates. And another great thing that was added to me is that Alex got additional funding to have public defenders there defending you at what a lot of people on the street call the TV judges. So it used to just be the prosecutor reading probable cause to the TV judge or the night magistrate, but now Alex's office staffs that, so there is a defense attorney there to balance the interests. But yes, we should be balancing the interest of public safety, which might mean there needs to be a surety bond with conditions, like if it's an assault, which we hear about some of the isolated incidents, like if there's a family assault, there should be conditions, there should be an emergency protective order, and it should be enforced by the current judges.
Is your office given the opportunity to have input on whether or not there should be bond conditions, for example?
Yes. Our office, the district attorney's office, is manned 24 hours a day, and we actually read the probable cause to the judges, and we suggest a bond. And then the public defender's office also suggests a bond after talking to their client, and then the magistrate makes a decision, and we certainly suggest conditions.
I want to chime in on something Gary said as well as you, Ms. King, because what I always want to do when we do shows, particularly like this, is make sure that viewers understand what we're talking about. And I know I'm sitting at a table full of lawyers, right? But I think it's important that the everyday person, grandmother, whomever that's watching this understands, as a result of the settlement that has happened, I think it's important for people to know at this point what are offenses that fall under this new settlement. Where are we now based on, I know you said some misdemeanors. Gary has said that he was appalled by some of the people that were released. Who falls under this new settlement to qualify for these types of bonds?
So the settlement only concerned misdemeanors. So misdemeanors are cases in which you can get only up to a year in jail. So they're much less serious cases. The most serious
not felons.
Not felons.
Okay.
The most serious kind of misdemeanor are typically domestic violence cases. And we have special exceptions for those. In fact, the Texas Constitution allows people to have to be detained in jail in some instances for those offenses. But most of the misdemeanors are things like trespass, minor thefts, things like that, where someone's promise to appear in court is generally sufficient. At worst, they might miss a court date, but people generally don't flee and abscond Harris County because they're charged with a misdemeanor. So on their promise to pay, they return. And the other parts of the settlement were that Harris County keep better data about what it's doing, and do better training for the lawyers, for the judges, and monitor to make sure that we're still enforcing this system. That's basically the terms of the settlement.
I've heard that the common thought, Gary, is that if you can't afford to pay a bond, you probably can't afford to skip town.
Not necessarily true.
And talking about, well, in a
listen to my next question. Statistics from your office, Vivian, say that 45% of all misdemeanor defendants are not showing up in court. Is that true?
That's what the statistics that have been provided to us.
Okay, well that.
In the old days, well, the Texas Code of Criminal Procedure requires, it says judges shall revoke the bond. I think a lot of the conversation in the criminal courthouse is about the judges not revoking the bonds, but maybe giving people another chance. So I think that has a lot to do with it. It's hard for us in the prosecution, as prosecutors, because we've been displaced. We're not in the same building where the court is, so we're going 1.5 miles all day long back and forth to court, and sometimes we cannot control our docket size. So it becomes a problem for us. But all in all, I think it's fair.
But as Dallas said, they're not leaving Harris County. Sure. Those people are ultimately arrested and returned to court, and they may have to face more serious consequences. In fact, my office specializes in representing seriously mentally ill defendants, often homeless. So in the old days, they would just stay in jail until they pled guilty, be released, and they might be back next week because that's where they are.
And that's
I have a question about your
I would like to
statistic.
make a
Go ahead.
comment about the mentally ill. So we have created a program where we've diverted over 2,000 mentally ill, where they don't even go to jail anymore. They go to the mental health system. Because the DA's office, did a statistical analysis and saw that a lot of those, what we call frequent flyers, the mentally ill that keep going in and out of jail, we were spending about $80,000 a year on them, getting them into jail, getting them treatment, and then they go back out and do the same thing. So we're asking the officers now, if it's low-level misdemeanors, instead of even booking them at all, where they have to deal with PR bonds, just take them to the mental health, the diversion center.
That's a positive. In fact, for our viewers, they probably are not aware that the state of Texas is building a long-term mental health facility on the campus where Harris County Psychiatric Center is, which will be also a very big positive for the mentally ill people in the system.
And that's an important step in reform. My wife spent a lot of time in the county jail as a mental health practitioner, and look, she stayed busy. And so it's important to really try to get people the treatment that they need. So I appreciate a comment you made, and then really a question about your statistic, Gary.
That's
in
from the
terms
DA's
of
office.
I get it.
That's
right.
it's real.
What was the statistic
Before?
Before.
That I don't know. It wasn't 45%.
Right? And so
We didn't try to calculate it before, because remember, the DA's office is not a statistical think tank.
right.
No, we have 85 to 87 police agencies we're dealing with in Harris County.
Right.
Harris County is bigger than 26 states
Right.
in the union. So we just take however many cases come in, and statistics don't matter. And the district clerk assigns them a case number and evenly distributes them among the courts.
Right,
So we
and
just,
it's good that you started doing that, but I think my argument to Gary's statistic is that I think if they weren't coming back, being released on bond, I'm sure that the number was probably the same, if not more.
That actually is, I'm sure it's not true, but I'll get it for you.
Okay, well,
I'll get it for
this
you.
is why we're
All right,
here.
I do want to mention, I have to mention one of the most egregious cases I heard about, because I think people need to hear, that shows a colossal failure in this present system, that shows you that even though, and I understand the reforms are work in progress, and it points out things we need to do. This is about Alex Bunin, who was convicted on July of 2017 of his first DWI. In May of 2019, he had a second DWI and a failure to stop and give information, meaning he was in an auto accident and left the scene. He got out on a free bond. June 31st, 2019, 26 days after release, he beats up his girlfriend and kills her cat. And he's charged with assault family member, and he gets freed on another PR bond. With no detention, no conditions. On August 4th, 2019, 34 days later, he goes home and kills his girlfriend, who is, by the way, pregnant, so he killed her baby too, and now he's in jail for capital murder. There is an example of a failure of our system.
Well, I'd point out a couple things. One, both the second DWI and the family violence are what we call carve-outs from the settlement. So a magistrate or a judge could have made a decision to have a high money bond in those cases, and in fact, family violence could have been detained. What we need is more information on the front end, more resources in making these decisions. What we used to have was a strict bail schedule. That was not helpful at all. All it did was look at the offense and set an amount of money and said, come back. We do need more resources up front, both for getting people out and in some cases for keeping people in.
well, generally in the old days, a person like that would be the magistrate or the TV judge would have them there, and then they would issue a very high bond, like $50,000, even though later it might be reduced to $1,500, so that they would see the real judge, the elected official, the next day, so that they could actually go over the magistrate's order of protection and actually say, do not go close to this person at these addresses within 61 days, and allowing the family to cool down a little bit. Of course, that could be eliminated or released from that, and then a reasonable bond would be set. What the DA's office is fighting is that the conditions are not being set by the magistrates or the TV judges as often as they should from the carve-outs that Alex is saying, and are they actually being enforced? Because we're getting many cases where people are cutting their GPS monitors, the judges are not finding out about it, violating protective orders. There's just been another stabbing or murder today. Someone's throat was slit. The orders are not being followed. And so we're real concerned about public safety, because unlike Alex, when it happens, they're calling the district attorney's office saying, why did y'all set this bond so low when we don't set bonds? Why did y'all not have conditions when we don't monitor conditions? we ask for them, but the judge is the one that makes the decision, whether it's the 24-hour magistrate or whether it's the elected official.
What has been the effect on our county jail system? I mean, in terms of, from a resource perspective, are taxpayers saving money? Has this, given better supervision to maybe some of those higher level offenders? Has there been a trickle down effect on the jail operations itself?
If I can start off with that, Alex, I would like to say, Alex and I were just going over that a minute ago.
Great.
The jail holds about 9,000 people. Right now, 359 have misdemeanors, and it holds 9,000 people. So only
that's great.
359. 160 of them.
But that sounds great. Is that great?
It is great.
Okay,
oh, it's
all right.
wonderful.
I'm
yes,
like,
yes,
sounds
because
great.
bail
I got a bed
reform.
for you.
Yes, because before bail reform, we had to outsource a lot of the people who were held in jail. We had to send them to Louisiana and other states and pay those jails to house them. So it in terms of resources, it's saving us money. The 359, 160 are held because they have a Bureau of Pardons and Parole hold, which means a federal hold. They have an ICE hold, or they're fugitives being held from other counties where those counties have to come and pick them up. And so there are very few people, or felonies pending, or because some felony is there holding them there. So they have a PR bond, they just can't get out because they have a hold, and that's 160 of the 359. So the rest of the people in jail, there's about 8,917 people in jail right now, and those are usually, there's a felony related.
Yeah, I don't know how much money you're saving. The misdemeanors cycled pretty quickly. As I said before, people would just stay until they pled guilty, and then they would get out. So they would go pretty quickly. But you're doing more justice because people aren't pleading just because they're stuck in jail.
Right.
And that was a bad thing, obviously.
That was a bad thing.
We didn't want to see that happen. Okay. One of the things I observed was it seemed like there was negotiations going on regarding settlement. DA's office was involved, Alex. I think your office was involved, and you had the outside firm. And it looked like the settlement and the confines of the settlement were pretty much everyone was happy with. And then Commissioner Ellis got into office, and things changed. He got a majority on Commissioner's Court, and suddenly the settlement became so egregious in the eyes of the District Attorney's Office that the DA's office opposed the settlement as going too far.
Well, one of the reasons why we opposed it was because in 2017, the DA's office agreed to not all PR bonds for non-violent misdemeanor offenders, which was the genesis of the lawsuit, where the 15 Republican judges did not agree with that. So we feel like it's already been working for a year and a half. So for this new think tank for the county, run by the commissioners who are in the majority, to have a $97 million consent decree, we thought was not a good use of taxpayer dollars, since there's only 350 people in jail, where before it might have been 5,000 misdemeanor people in jail, cycling through quickly, like Alex said. But why spend $97 million? One of the things we disagreed with at one point is they wanted to give Uber rides and babysitters to people, and we just thought that was, even Judge Rosenthal didn't agree with that. And so it was all the conditions. I do agree that some money should be spent on statistics and creating statistical analysis, because that's not anything we ever worked with before. But it just seemed like it was a big price tag to add to the consent decree when we were already doing it.
Well, and especially since Alex pointed out, I think correctly, that one of the things that's needed in the system now is more information. We were talking before the show about the amount of information that's provided to lawyers who work in juvenile court, which I do. You walk in, you get a pre-sentence report in essence, which tells you all about your client's background, his family, and history, which gives you and the prosecutor and the judge a lot of information about whether the child should be released or not. And that, I think, would be a major asset in the adult side.
What's weird is that there was a time when in adult court, we would get the pretrial report that showed their family contact, their connections to the community. Remember that? I mean, that might have been 20 years ago, but I remember they used to give us that.
Gone.
Well, and I'm saying us like I'm still defense, but you know what I mean. They used to give it to both sides, the prosecution and the defense. But I'm not sure that's happening now.
Well, I think Alex started off the conversation saying that, the reason why this became so contentious in the county was because it was a political divide and a political rift. Right. Political winds shift. The court became more democratic. It became more progressive. And ideology indicated that they were pushing forward with what they felt as though was a sweeping bail bond reform plan. I think the question becomes, I would put out there is, as Ms. King talks about the price tag of the reform itself, how much did the county spend fighting the appeal of the case?
It was about $9 million.
All right, so that's not close
About
to
9 million.
96.
About
mean-
$9 million.
I
About
mean, you have to
9 million.
understand that in the settlement, a lot of the things that were objected to and Vivian just spoke about were presented by the plaintiffs. They weren't presented by the local folks here, and so they had to come up with a settlement that everyone agreed on. And a lot of what's being done are things that will help get people to court. So, texting folks about their court dates, reminding people. A lot of studies have been done. If you just stay on top of folks, they'll show up.
Well, that's what bail bond companies did when they were supposed to inform people who wanted to go to court. And by the way, in juvenile court, the probation department contacts the families regarding every court appearance. And some still don't show up, by the way.
And that can be still done by pretrial. There's other ways to do the same thing that don't cost as much, because when we do our pretrial diversion program for marijuana at the DA's office, they're never arrested, they never go through the system, and we bought a text program. We remind them every 7 days to go take your class that you're supposed to take in 90 days so that we don't charge you, charge you with the offense. We text them, and we just have paralegals that do that. And
Yeah.
and it never touches the system. So there are cheaper ways to do it.
But what happens if the DA changes? And therefore the approach and methodologies, or even the policy that you put in place, is not actually codified, and rather it's more of an administrative rule. How do we then ensure that justice is continuous?
In terms of the diversion programs, if there is a new DA, which I hope there isn't, the policies can certainly be changed. Diversion is something that's legally authorized by statute. So any DA can do diversion programs on certain offenses. So hopefully the good work that we've done, we'll be able to continue to do it.
Those behind the reform, and I would put Commissioner Ellis up there at the
I
top.
love talking about Rodney Ellis.
I
Gary.
do. Well, because it's a fact. His hands are all over this. He wants to now bring this party to felony courts. Much more dangerous to law-abiding citizens to do that. And in fact, his pressure has already affected our felony court judges, Alex. I'm sure you've observed it. Some of the courts are issuing PR bonds like candy for serious offenses, for bonds. I mean, there's a bond, one judge said $500 on a failure to register as a sex offender, a ridiculous number, up to $35,000, which is, and the cost is $100. I think they use these numbers to make it look like they're being really tough, but they're not. $100 is what the fee is to the accused. The same it would be for a $500 bond, I guess. So that's what's happening, and they want to take this fandango to them, and then we're going to have a bunch of felons loose with prior history, because we've not done a good job in the system we've created of knowing the facts, as you correctly pointed out. So is this a good idea or a bad idea, or should we learn to walk before we run?
Well, I listened to your anecdote, and I realized that may have happened, but it's not happening among all 22 of our felony judges. And in fact, what I see is a lot of them raising bail. So I do not think there's any epidemic of felony judges willy-nilly releasing.
But the proposal by Commissioner Ellis is to expand what was done in misdemeanor courts to the felony courts. There's no
to be
question
fair,
about
and
that.
and I'm sure Commissioner Ellis would not be afraid to accept that, but it is a felony lawsuit. There is a federal
I understand.
lawsuit that is in place, and we'll have to settle that at some point.
And I'm actually shocked, Gary, that you would kind of create this what you've presented to us as, you know,
He is
it's one of
behind
those.
this.
It's kind of that here's the red meat of the big bad wolf is coming, and all of the criminals are going to be released on the
Alex,
streets
Alex.
to rape and pillage your neighborhoods. I think that's a bit extreme.
If we're not careful who we release, it is dangerous to the public.
I
That
think
is a
I think
fact.
the public would agree to that,
And
but
if
I'm
you
not
look-
sure
if
that
you look at-
within what you are proposing is going to happen, as Mr. Bunin has just pointed
Well, he
out.
already-
I'm not sure that's the case.
Okay.
Well, let me add this. The Russell lawsuit, that's the name of the felony lawsuit, has been filed. It just hasn't been acted upon. And so it's coming. It's just not ripe for discussion yet, because we're not there yet. But we are concerned because some of the newer felony judges are issuing a lot of PR bonds and felony, even though it's not related to the lawsuit. And it's concerning to us because there are people who are career criminals who are out on 5 and 10 PR bonds. They keep committing crimes or getting accused of committing crimes, getting a PR bond, felony PR bonds, and going back out doing the same thing. A lot of them are low-level crimes, but they still are crimes. Some of them are burglary of motor vehicle. We get a lot of calls. That's a misdemeanor now. It used to be a felony. It's a misdemeanor now. But your third one is a felony. So some of them are being charged with felonies. If they keep getting PR bonds and they have 10 of them outstanding and they keep breaking into all the cars in the parking lot, that's a problem for law enforcement. It's dangerous for the police officers to keep arresting the same people over and over, and their cases have not been disposed of. So that's the type of problem we're having, is with the habitual criminals that keep doing the same thing.
So how do you get 10 PR bonds?
Because you get a bond.
Arrested.
No, listen to this. You get arrested, you get a PR bond. Then you go out, your court date is say next Friday. You go out and you get in trouble again on Thursday. You get arrested again. You get a PR bond. You don't show up for court on Friday, but then you get another court date 2 weeks later for both cases because they track to the same court if you already have one case pending. So then you get another PR bond. Your court date is in 2 weeks. Some judges aren't enforcing or revoking that bond when you don't show up. So then you get another PR
So that's
bond.
a judicial matter, though, right?
It's
That's
a judicial matter,
That's a judicial
and
matter.
it depends on what the offense is,
But the
what
call
the
comes to the
circumstances
district attorney's
are.
office.
That's our show for today. Thank you so much for being
Very,
here.
very informative.
Very,
Thank you
very
very
informative. This has been another episode of Red, White, and Blue. I'm Dallas Jones from the left.
Gary Polland from the right.
See you next week.